The exclusionary rule says evidence obtained illegally cannot be used at trial. Remember, you are innocent until proven guilty. So if we can say the evidence was not found in a legal way, then you're off the hook, right? You're innocent. They don't have what they need, the prosecution, to prove that you've done anything wrong. So this is the concept you want to make sure you remember. The exclusionary rule says that evidence obtained illegally may not be used at trial. You'll see here it says, I don't care that your conviction was overturned. Up here, we don't follow the exclusionary rule. You know, in heaven, they don't care. The purpose of this rule is to make sure that police follow proper procedures when they conduct a search. So as a police officer, you have to be familiar with what is okay and not okay in a search, where you can't just kind of abridge our freedom that we have and our privacy that we have under the Fourth Amendment just for any reason. You have to have probable cause. The judge needs to agree and give you a warrant. And there's only a few exceptions. There's 7, but there's only a few exceptions to that. And if they do find that evidence in a way that violates your Fourth Amendment right, that evidence can be excluded from trial under this exclusionary rule. Jacqueline.
Where would the fruits of the poisonous tree come in hand with this? Because I've heard you say that before.
Fruits of a poisonous tree?
Yeah.
What do you mean by that? I don't know
Like
that that's
evidence. And you've said it once before, I believe, where evidence obtained some certain way would be thrown out because it wasn't legally obtained.
Absolutely. So when it's thrown out because it's not illegally obtained, we can throw it out under what rule? Exclusionary rule. Okay? So if a cop just comes and decides like, hey, I'm going to drop by John Carlos's house today, and goes into the house and John Carlos says, no, you may not go into my house, and the cop goes in anyway and starts searching without a warrant, unless they can somehow argue they meet one of those exceptions, if they find something not okay at John Carlos's house, they can't use it as evidence against you in trial under this exclusionary rule. So this is where a lot of the arguments you might see in a criminal case happen, is whether or not that evidence may be allowed into the courtroom in the first place. If we can keep a really vital piece of evidence out, like the gun, it could be very hard to prove someone committed murder. Alan.
Will this be done usually like in the discovery phase or just during the case?
So this is something you could do during the discovery phase, absolutely. You'd say, hey, this person is trying to put this in trial, and you can ask the judge to file a motion asking it to be excluded under the exclusionary rule. It can happen in that phase as well.
Would a cop need a warrant to search something that's like on your property but not in your house? Like if you had drugs in your mailbox, would a cop need a warrant to search that?
Ben, I love this. You guys are finding all the loopholes. That's what lawyers do. Good thinking, okay? Thinking critically about this. Well, does the mailbox count as your property? A mailbox is actually technically federal property. But if you put something in it, then maybe it's yours. I don't know. And so you look to what to figure that out? Precedent. So I'll tell you, like a lot of precedent will say, like your porch is your home. It's still your property. Your land, it's your property. It's part of your house. So your backyard, your front yard. But just so you know, like here in Maryland, I own the land and my house, but about 6 to 8 feet from the road, it looks like it's my land. It's actually the county's. So I have like trees planted there. They're mine. But when I was doing some zoning work, usually that's the county's in case they decide to ever put a sidewalk in, they'll be able to. So I don't own that little strip, so I might not have a lot of protection if someone throws some drugs in those trees. Okay? Don't go to my house and do that. So we're going to move on to some of the other rights we have under the Fifth Amendment. So again, we want to make sure people get a fair trial. We have a lot of protections under these amendments put in place to make sure that those rights are not abridged, and that no one has too much power and is taking away some of this fairness that should be given. So as part of that, we have this case called Miranda versus Arizona. Who has heard of the Miranda rights before? Have you heard of the Miranda rights? Be honest. TV. So what do they say?
The cops didn't say they're the Miranda rights.
Yeah, they cuff them, and when they cuff them, when they're arresting them, they say something like,
You have the right to
right to remain silent. What you say can be used against you in a court of law.
Can and will.
And it will be in some cases, and
Right to an attorney.
you have the right to an attorney, and if you can't afford one yourself, you might have to prove you can't afford one, but if you can't afford one yourself, one will be provided for you. So you're being told your rights because not everyone's aware of them, right? You guys are in this class and you're learning them, but on average, a lot of people aren't in college, and even some of the people in college don't take a law class and find this out. And so this is the famous case. Now you know the precedent that created that. Every time you watch Law and Order and you see them saying that, now you'll know it was because of Miranda versus Arizona. Okay? So here's what happened in this case. There's this guy named Ernesto Miranda, and he's mentally ill, and he's an indigent citizen of Mexico. The Phoenix police in Arizona arrest him at his home, and they bring him to a police station where a rape victim identifies him as her assailant. Remember, he's innocent until proven guilty. So 2 police officers took him to an interrogation room. They didn't tell him that he had a right to have a lawyer present during questioning. 2 hours later, the officers emerged with a written confession signed by Ernesto Miranda. At the top of the statement was a typed paragraph, and it stated the confession was made voluntarily, with full knowledge of his legal rights, understanding any statement he made could be used against him. So here's the history of this. At his trial, the judge admitted this written confession. You would argue, if you're trying to help Miranda, you're going to argue under what rule that it should not have been admitted?
Miranda.
Under what rule should it not have been admitted? Miranda rights don't exist yet, and you're going to argue under what rule we just talked about that they should exclude this piece of evidence? Exclusionary, there you go. As soon as I said exclude, it came out. Under the exclusionary rule, you argue they shouldn't have. On trial, the judge admitted it. So the officers testified that Miranda had also made an oral confession in addition to the written one. The jury found him guilty of kidnapping and rape. I mean, that's a written confession, along with cops testifying he made a verbal one. It seems like he did something wrong, right? He's sentenced to 20 to 30 years in jail. So obviously, we see an appeal happening here, right? This gets appealed to the Supreme Court of Arizona, and they affirm the conviction. They say, yeah. In reaching its decision, the court relies heavily on the fact that Miranda never requested a lawyer. You know, yeah, you had a right to one, but you didn't ask for a lawyer. The Supreme Court of the United States, so now we're at the federal level, just like the U.S. Supreme Court cases you guys will be looking at. This is a Supreme Court case at the federal level, the highest court, and they're saying this is so important, we need to look at this. And so the issue here is, was Miranda's confession admissible at trial? And if so, should his conviction be upheld? What do you guys think? Is it admissible? I mean, a lot of courts said yes. What did the Supreme Court say? You're a justice on the Supreme Court now. What do you say? No, why not, Jacqueline?
He never knew his right, and they should have taken into account that he was mentally ill.
Okay, so they know his rights. He's mentally ill. Why does it matter that he's mentally ill?
He might not have the same comprehension of what his rights are.
Good, so Jacqueline says, can you comprehend? You might not be able to comprehend and understand what you're giving up by signing that statement. So that certainly is really important here, the fact that there's a mental capacity issue. Veronica, did you want to add something? Ben.
Does he have the right to a lawyer if he's a Mexican citizen, not a U.S. citizen?
So you have a right to an attorney if you're here, right? So he's here, he's in Arizona, he has that right to it, but that's a good point. That's a good thing to bring up. So here we're looking at his conviction. Should it be upheld? One really, really good point Jacqueline made we had already is about, mental capacity. I'm going to go back to the facts here. Anything else that seems funky here?
That they wrote that he had a full knowledge.
They wrote he had full knowledge. Why does that seem to be a problem? What language was this in?
English.
Okay, what does he speak as his primary language?
Spanish.
Spanish. So maybe would he be able to understand that?
No.
If someone wrote that in Spanish for me, I wouldn't understand what I was saying. So that seems a little unfair too. So looking at this, the judge has absolutely said, you know what, this is not fair. Okay? We can't expect the average citizen to understand that they have this right. And so prior to the questioning, you should be warned. You should be told you have this right. To have a lawyer present at all the important stages of the trial process, including when you're being arrested, right? At any stage of the process they wish to consult an attorney, you should be able to. And that seems fair, right? You should be able to get advice about the law when you're in a bad situation. If you're alone, indicates any manner that he does not wish to be interrogated, the police may not question him. He didn't get a chance to even say, I don't want to be questioned. And the mere fact that he may have answered some questions or volunteered some information does not deprive him of his right to refrain from answering anything further. So if you start helping a cop, they're asking you questions about something. And the fact that you answered a few questions doesn't mean you have to answer the other 100 questions they ask you. If it starts feeling uncomfortable, like maybe they think you did something wrong, you have a right to stop at any time and get an attorney. That's the idea behind our trial process. We want to make sure things are fair, right? You're innocent until proven guilty, so we want to make sure that you're taking advantage of those rights. So because of this now, it says in this cartoon, Should you not be able to afford an attorney, the state will provide one for you. On the outside chance you should be convicted and actually go to jail, the state must provide more attorneys to endlessly pursue appeals on your case until you are released, or the state goes broke, whichever comes first. So here, the holding we see from that testimony, the mere fact that he signed a statement which contained a typed-in clause saying he had full knowledge of his legal rights does not approach the knowing and intelligent waiver required to relinquish those rights. You'll see if someone at trial is saying, I'm guilty, they're pleading guilty, the judge will go over what their rights are with them. You understand, you have a right to a trial, you understand this means you're going to be sentenced, and so that way they're saying with full knowledge, well, yeah, I understand what my rights are and I agree. But they'll always repeat that. Same thing here. And that's why we have these Miranda rights now. So again, under the Miranda rights, thanks to that case, when arresting a suspect, the police must inform her that she has the right to remain silent, anything she says can be used against her, and that she has a right to a lawyer, and even for free if needed. If you need a free attorney for a criminal case, you might need to prove it is the only thing. The county can ask you to provide certain documents showing your income. So here we see the Miranda warnings, and you can waive those rights. You don't have to have an attorney present, but we just want to make sure you understand them before you do. Now, self-incrimination is also something that you've probably seen in the business field quite a bit. This is that idea that the prosecution may not use coercion. They may not force a confession from a suspect. And a suspect may refuse to answer any questions that could convict them. So this is interesting. You've probably seen this before. People say, I plead the fifth. This is your protection under the Fifth Amendment. Under the Fifth Amendment, you have a right against self-incrimination. So when they're saying, I plead the fifth, it's because they don't want to provide written testimony or verbal testimony that would incriminate them in some way. So sometimes people just say simply, I don't recall or I don't remember. But a lot of times they'll say, I plead the fifth. They're using their Fifth Amendment right not to incriminate themselves. Now, defendants often will do this as well. Do defendants have to take the stand and speak against themselves? Under what law? Under the Fifth Amendment. So remember, you don't have to incriminate yourself. A defendant does not have to take the stand. A defendant is innocent until proven guilty. So if they take the stand, they're sharing information that may help their case, but then who also gets to ask them questions? Yeah, right? The prosecution gets to ask them questions too, and it could make them have to give information that could hurt them in the case. So a lot of defendants actually don't bother taking the stand. They don't want to be subject to that cross-examination, which could, even if it's not the greatest discussion, the jury's seeing all of it, and it could just make them look kind of guilty. So they just won't take the stand, and juries don't always understand that. They don't know that's why they're not saying anything. You should speak up, right, and advocate for yourself if you didn't do anything wrong, but they'll often be advised not to take the stand to avoid additional testimony that could hurt their case, because they're innocent. If they say something, it could get them into that reasonable doubt area. So that's why a lot of defendants do not take the stand. Now, under the Sixth Amendment, this is where you have a right to a lawyer. This guarantees criminal defendants the rights to a lawyer and to have them present at each stage of the process, including prior to police interrogation, as we saw in the Miranda versus Arizona case. A public trial without unnecessary delay. How long do you think again, we saw that public trial thing that you can go into court at any time. What seems to be like an unreasonable delay? How do we know what's too long? If I'm charged of a crime, how long should it be till I'm brought to court? What did you say, Andrew?
Jury selection.
When should the court have to take me? Because let's say they're holding me in a jail cell. How long can they make me sit in that jail cell before my trial where I'm innocent until proven guilty?
24 hours.
24 hours?
12 hours.
Till maybe I'm charged. So Yang brings up a good point. We'll look at the criminal trial process in a minute. They have to actually charge me pretty quickly. But until my trial happens, how long should I have? What do we look to figure that out? Precedent. Okay, so I'm not trying to trick you. Precedent. Precedent in Maryland says usually 180 days. Counts as a speedy trial.
Wow.
Now they extend beyond that often, right? Because that's not that long. We're talking 6 months, right? I mean, that's a long time for me to be in. I don't want to be in jail for 6 months, right? But that's not that long. So a lot of attorneys will ask for an extension. They'll ask for what's called a continuance, and often it will be granted. And that's something that we've observed in our court visits before. So the trial process is a little different when we're talking about criminal trials. First, there's an indictment. What this means is there's a grand jury. They're ordinary citizens. You can serve on a grand jury, just like a regular jury. And it determines that there's probable cause to proceed to trial. That's it. So a lot of evidence is allowed in the grand jury process. Okay, because this isn't an actual trial. All they're deciding is, is there enough probable cause here that the state should be able to bring this to a real trial? And so then they will charge you with a crime in what's known as your arraignment. So at the arraignment, they'll read the indictment to the suspect, who then pleads guilty or not guilty to the charges. So that happens pretty fast. We can charge you with a crime relatively quickly. And the judge will make sure you understand what's happening there. Then we see this plea bargaining. This is that negotiation process, because remember, most cases settle outside of court. Criminal cases can too, through plea bargaining. The prosecution can offer to end the case with reduced charges to the defendant if they'll plead guilty. Why would the prosecution want to reduce the charges? If they can get you 10 years in jail and they're mad because you did something wrong, why would they offer to give you only like 5? Yeah, go ahead, a little louder.
But to save time and money?
Yeah, save time and money, and are you innocent until proven guilty?
Yeah.
Is it hard to get 12 people to agree that you're guilty? Yeah. So they'd rather make sure you have some type of consequence, not have to waste all their resources here, then they can use the resources on some of those really important trials they might need to focus on. Okay, so here, you can also appeal. So there's a trial that'll happen, just like we've seen that trial process many times now, and you still have the right to appeal in a criminal case, and even to the Supreme Court. Some of you will look at Supreme Court cases in the United States for the project coming up. So similar process, the kind of added piece to what we've talked about before is the indictment, okay, where they're saying, hey, you did something wrong, a grand jury deciding this is probably something where you should go to trial, and then the arraignment where they're saying, here are your charges against you, you have to plead guilty or not guilty, and then plea bargaining is where we can see some type of settlement, hopefully. Just so you know, the state's coming to an agreement with you. They're saying, instead of 10 years, you can risk going to trial and maybe getting 10 years, we'll give you 5, a lesser sentence, trying to get you to just agree ahead of time. You can negotiate whatever you want that to be. The judge also has to agree with it, though. So I know someone who did something really, really, really awful. It was a friend of a friend. It's horrifying even talking about it. But we'll learn next class about embezzling money. They were embezzling a lot of money from a nonprofit organization and using it to take fancy trips and things. Okay, so they were using money that they had access to in the organization for their own personal benefit. It's known as embezzlement. And they made a plea bargain where they weren't supposed to have any jail time. The judge was furious about what they did, and the judge ended up putting them in jail still anyway. So she pled guilty, and then she still ended up in jail. You can come to an agreement, but the judge has to be okay with it too, and in that case, they were not. It was because what she was doing was really, really bad. Go ahead, Santi.
So you don't know how the judge feels until you actually go.
No, they might not accept the plea bargain, and that's what happened. They didn't accept it. So, Double Jeopardy. You've probably seen this movie. I have a little clip from it. I'm not going to show it to you, but if you're interested, you can watch it. A defendant can only be tried once for a particular offense, no matter what's found later. So after you've exhausted all appeals, generally, they will not allow you to have another trial, right? We went through this process. If we found you innocent, you're off the hook. If we found you guilty, you're guilty. If you've exhausted all the appeals, you've gone to the Supreme Court level, you're done, right? Now, that's a long process. It can take a long time. The idea here is that you have one trial. You murder someone, you get the one trial for murder. You're not going to be retried later about it. If you're off the hook, they found you innocent, and it's not fair. That being said, sometimes they make exceptions to this if there's some big piece of evidence or something they discover later. So some of you might be looking at that Serial. The Serial was based out of Baltimore. There was it's called a podcast?
Yeah.
Thanks, sorry. It just slipped my mind. There's a podcast on Serial, and so after that podcast came to light, all of a sudden new evidence was coming to light. They can allow you to have a new trial if it's something that really is exceptional. The last piece we're going to talk about today is cruel and unusual punishment. Okay, generally, the punishment should fit the crime. And so we have precedent under Furman versus Georgia. Again, this is a U.S. Supreme Court case. We see that in the citation here from 1970s. The court defined the test to determine if a punishment is just too much. Under the 8th Amendment, it has to be a fair and reasonable punishment. So we'll talk next class about the sentencing guidelines. It's too much if it's an unusually severe punishment. If there's a strong probability that it's inflicted randomly or arbitrarily, and if it's substantially rejected by normal society, or if there's no reason to believe it serves any penal purpose more effectively than a less severe punishment. So there's a lot of controversies around this. Excessive fines. Sometimes someone who really just doesn't have the money won't be able to pay, and all of a sudden they're getting these fines that are making it so that they're thrown in jail because they can't pay a $100 fine, and it's a horrible system. And then while they're in jail, they can't pay that fine either, and it starts adding up and adding up. There's 3 strikes laws where if you've done something more than once, it can be a more severe crime, and that's very controversial. The big one in the last couple minutes here I want to share with you, for those of you that are interested, is capital punishment. And under capital punishment, you can be sentenced to death. And some people would argue that that's never going to be a reasonable thing to do. So for those of you that are interested, this is in the learning module. This was in Time magazine. It's called Fatally Flawed by Josh Sandberg. This will give you a breakdown about a situation where there was someone who really did something awful. He raped this woman. It was a horrible, horrible scenario. It's this guy here. This is his son. The fact that he did something awful was clear, but it took them, when they do capital punishment, there's different ways they do it. This shows you here in Execution in America. There's a nice little chart that shows you the different types. This was hanging that was done up until the mid-1900s. More often now we do electrocution. There are some gas chambers, and then injection is what we really do today. You can see kind of the history of this. And this gives you a nice graphic of how much happens in which state. A lot of states completely outlaw killing somebody. You know, that you would be punished with death if, say, it's too severe and it violates the 8th Amendment, but not all states do. Okay, so in 35 states, they sanction the death penalty. And so here you can see, like, one of the, Texas obviously has some of the most deaths as a result. So I just wanted to show you that. Any of you that are interested, it's in the learning module. The problem in the Time article here was not that they put him down, that he was, treated for rape with having a death sentence. It was the manner within which the injection works. Those injections are made of 3 parts. They're often administered by someone who doesn't know how to administer a shot. So it wasn't that he was put to death. It took like 18 minutes, and he was like violently, freaking out as it's happening, and the son's observing all of this. So it was it not that he got put to death? Was the death too gruesome? Was it too much? Was it too mean? Too severe that it violated the 8th Amendment? So that's where we'll stop today. When we pick up next class, we'll be talking about specific crimes. I'm happy to address any questions. Just put your name tags back and make sure you put the seats back. I will post this video for those of you that are interested.